Hello, good morning. Let's get started. So on Monday we began looking at the various legal and equitable doctrines relating to mistake on our build-up to looking at how the statutory provisions that were introduced in New Zealand in the 70s deal with some types of qualifying mistake, but as we will see next week, certainly not all possible mistaken situations. And on Monday we looked at this idea that prior to the legislation, the common law considered mistake to be a question to be dealt with in the formation stage. Were the parties actually in agreement or not? And that equity, the other strand of jurisprudence that's deeply embedded in English and New Zealand law, would come in and say, even if there is a concluded contract in the common law, there may be grounds for what's known as rescission of the contract under equity, where one party is mistaken as to a fundamental nature or some key feature of the contract, and the other party knows that that other party was mistaken and seeks to enforce the contract against them anyway. And in those cases, equity said it would be unconscionable for the party to enforce the contract knowing the other party was fundamentally mistaken, and therefore we will grant rescission, which means that the contract may have existed as a matter of common law, but is unable to be enforced as void thanks to this equitable doctrine of rescission. Rescission was discretionary in that the courts did not have to grant it. It was an equitable doctrine. And it was also required that the mistake was fundamental in nature. It could not just merely be that some aspect of what you were contracting about was not as good quality as you'd expected. It had to be something more fundamental than that. We then looked at, so that was how the common law and rescission dealt with mistakes generally. That is not how we would look at mistakes now, thanks to the Contractual Mistakes Act, now the mistakes part of the Contract and Commercial Law Act. But there are a couple of doctrines that pre-existed the mistakes legislation and that still exist even after the passage of the mistakes legislation, thanks to that saving provision that we looked at on Monday. And those are non est factum and rectification. Non est factum we looked at on Monday, and we saw that non est factum is a common law doctrine. It's a strange common law doctrine in that it seems to go against the idea that if you sign something and it's in writing, then that's the end of the matter. But it is a narrow exception to that position. And it says that when you have signed a document, originally a deed, but then expanded to simple contracts, when you have signed a contractual document, you are bound to it unless you can show that what you agreed to was fundamentally or radically or very different from what you thought you were agreeing to. And the reason what you signed is not what you intended is not due to any fault on your part. And that you were misled in some way and by someone else, and in trusting that other person you were not being careless or negligent in the, not in the legal sense of negligence, but just in the everyday usage of being careless. And if you could show that, then the courts would say there was no consent to this written agreement and there was no contract at all. There was never a contract between you. And if that's the case, then any obligations arising from this contract don't exist. This obviously can have implications for third parties, and as we saw on Monday, the courts are well aware of and are concerned about the effects that a finding of non-est factum will have, not only to the parties to the contract, but also to any third parties who may have relied on the contract being binding, such as a lender lending money on the strength of a contract, for example. And if there are innocent third parties who will lose out because the contract has been declared void because of non-est factum, then the courts will, in all likelihood, not grant non-est factum, because they say, well, between someone who signed something and is seeking to get out of the effects of signing a contractual document and an innocent third party, we're going to place the losses on the person who signed the contract. And so that's why the Bradley West was decided in the way it was. Bradley West solicitors, they were concerned about the impact that that would have on other parties, a finding of non-est factum. And that was why the finding of non-est factum, one of the reasons why non-est factum was successful in the Lansdale case, and that the only parties affected were the two parties to the employment agreement, and the only one whose rights would be affected was actually the employer, and the employer was the one who misled the employee as to the nature of the agreement he was signing. So the courts said there was no reason not to hold non-est factum in that case. Okay, so non-est factum still subsists to this day, is still a valid defence. Are there any questions at all about what we did on Monday? About non-est factum, rescission? No? All happy? Okay. Well, the other doctrine that pre-existed the mistakes legislation that still exists after the passage of the mistakes legislation is rectification, which is another equitable doctrine. Preserved, as I said, by the CCLA 2017, and it's equitable. So again, we're looking at whether or not the enforcement of a written document would, as it stands, would be unconscionable, or if equity should step in and seek to relieve one party from their obligations in certain circumstances. The difference between rectification and rescission is firstly, is the result. Remember I said with rescission, the outcome was either the contract was rescinded and it was completely unenforceable, void, no obligations subsided afterwards. There was no contract, essentially. It's rescinded in its entirety. Or it's enforced in its entirety. It's one or the other. There's no middle ground. Rectification is different in its effect. If you successfully plead rectification, the contract is changed, rectified, and then that changed contract is enforced. So you are seeking not to do away with the contract, but to amend or rectify the contract to bring it into line with what the parties actually intended. Like non-est factum, we are talking about a written agreement. It only applies to written agreements. And it applies to written agreements which do not reflect the parties' actual intentions. That there has been some mistake between what the parties intended and putting that intention down onto the paper, writing it down. And I've used this example before, but it can be as simple as a mere clerical error. You are a retired law clerk at 10:30 at night. You're being asked to draw up the agreement on the basis of some badly handwritten notes given to you by one of your partners. And instead of putting the price in at $10 million, you put it in at $1 million. You forget a zero. Or $100 million, you add a zero. And for whatever reason, the parties don't pick it up. The agreement is signed with the wrong price. And then one party seeks to rely on that changed price and said, oh yeah, I know we agreed to $10 million, but actually the written document says $1 million, that's what you signed, too bad. That's when rectification would come in, or an argument of rectification would come in and say, Your Honour, we agreed or we intended that the price would be $10 million, and we intended it all the way up to the signing. There was a mistake in the written document. Please rectify that written agreement, put in the right price, and then enforce it, because that's what we actually intended. So you can see it's different again from the common law, in that in the common law, as I said last time, the writing is the agreement. For the common law, what you write down and sign, well, that's your agreement. We don't care about what was in your head or what happened beforehand. The entire point of writing an agreement down and signing it is to cut off everything that went before. It gives you certainty. It ensures that you read your document carefully. It ensures that you don't get underpaid, overworked law clerks to draw up your agreements, etc., etc. Equity, though, says, yes, the writing is important, but only as evidence or only as a reflection of what the parties actually agreed. And when that actual agreement or actual intention differs from what in the writing, then equity says we can come in and ensure that the writing does reflect the agreement actually made by the parties. So the courts will rectify or change a document to accurately reflect what the parties intended, and then will give effect to that amended contract. And essentially, the rationale for this is the same as for rescission. That we will not allow an innocent mistake in the writing to be used by the other party fraudulently. And what I mean by fraudulently then is by using it in a way to take advantage of, where they know that's not what they agreed to. They know that the price they agreed to was $10 million. The price was always going to be $10 million. There has been an innocent mistake in drawing up the writing that no one's picked up, and you are then trying to rely on that written document to get around having to pay the full price. The courts would say in that situation it would be unconscionable for you to use that innocent mistake in the writing to get a better bargain than you'd actually had with the other party. Okay, if you were trying to claim rectification, so how this comes to court is you've got the written agreement, right? And one party seeks to enforce that written agreement, the other party seeks to escape the consequence or escape the enforcement of this written agreement by pleading rectification. If you're pleading rectification, then the onus is on you, obviously, to show that rectification should be granted in this situation. So that means you need to show, most importantly, that both parties had a common intention different from the written agreement, and that that common intention continued all the way up until the moment that that written document was drawn up and signed. And that was not merely one party wanting the price to be $10 million rather than $1 million, but that both parties intended it. The both parties had come to an agreement, and that agreement on that particular point continued all the way up until the signing. And for whatever reason, that agreement was not accurately reflected in the written document. Therefore, if the defendant or the party seeking to resist a claim of rectification, seeking to rely on the written document, can show that they'd always intended the price to be $1 million, that what the contract was what we always thought the price was, and we had no idea that you were wanting $10 million and had a different intention, then no rectification would be available to you. Why? Because the parties don't have a common intention that continues up until the date of signing. There is a wrinkle to that, which we will come to when we look at the A. Roberts decision. But the paradigmatic rectification case is the parties intended X, continued to intend X, continue, moment of signing, document says Y. Your Honour, let's rectify the written agreement so that it says X to reflect our common intention. And just to be clear, rectification is for written documents. That is, written contracts. Oral contracts can't be rectified because there's not a written document reflecting that agreement. Okay, we'll go to a great case to illustrate this rectification doctrine, Dundee Farms. But before we get there, are there any questions at all about this? Okay, it's an equitable doctrine. Therefore, you're going to have to show that enforcing it for one party to rely on the written agreement would be unconscionable. And you're also, it's discretionary in that the courts may refuse to grant it for bad behaviour on your part, for example, if you fail to come to the courts with what's known as clean hands. But it is also, you're always going to be up against the fact that the other party has the written agreement and has therefore evidence, very good evidence, of what you intended and what your bargain was. And therefore, to show that your intention, your common intention between both parties was different to what was written in the agreement, you're always going to be on a slightly down, you're going to be arguing uphill, if you know what I mean. You're trying to overturn this presumption that the written document is what you intended. You're going to have to show some good evidence to overturn that presumption that the written document is what you agreed to, and that this might be hard to do. Not impossible, obviously, but you're going to have to show evidence somehow of that common intention. And you're going to fail if you can't show that that common intention continued up until the moment of signing, which means you can't... So, for example, to go back to that price example, if the parties are still negotiating as to the price all the way up until the moment of signing, then you can't show that there was a common intention that the price was $10 million. Instead, the price reflected in the written document is the final outcome of the negotiation, and it overtakes previous offers or counter-offers, and then that would not be a good grounds. There would be no grounds for rectification in that case. There was no common intention that you could look to. Instead, there was merely negotiation, which was finally brought to an end in that final written document. Okay? So it's not an easy argument to run, and nor should it be, because we should be able to rely generally on someone's written agreement which they've signed up to as reflecting the bargain actually reached. If we too easily allowed parties to change that, then the ability to rely on those would be severely undermined. Okay, let's have a look at a good example of it, Dundee Farms. So it's a good example of the rectification in action. This was a sale and purchase agreement of a farm down near Pukekohe back in the 70s. The farm, the purchasers wanted to buy a dairy, effectively a farm, so they could run a dairy herd on. And they were shown around various farms, including this farm that they eventually bought, or at least that's the subject of the dispute. So the farm was about 544 acres. There was, though, some dispute because some of the maps were not entirely accurate. And so therefore some of the statements made about the size of the farm were contradictory, and sometimes the farm was described as being about 550 acres. In fact, it was about 544. The purchasers, as I say, prior to buying it, had inspected it. They'd talked to the owner. They had shaken hands and said, yeah, I like this farm, I'll buy it. We'll meet up next week in your solicitor's office to draw up the agreement. Interestingly, they'd had an indication about the price, but there was no, when they shook hands, the two parties hadn't discussed the price directly. They came to the solicitor's office next week. There was a discussion about the price, and then they said, okay, that's fine, we'll buy and sell for $220,000. Let's draw up the agreement. The solicitor for the vendor had got down the titles that made up the farm, and there were 3 of them. And they made up about 544 acres. The solicitor for the purchaser said, 544, that seems a bit small. I thought it was a bit bigger than that, relying on these other statements about the farm being about 550. Maybe there's a title missing. And the vendor solicitor said, I don't think so. And then the purchaser solicitor starts rummaging through his file, which has all the titles owned by the vendor, and says, look, what about this one? It's about 12 acres. And if you kind of fit it on, it looks like it fits into the back end of the property. And that would make it up to what I think the acreage should be. And the vendor's solicitor's like, I don't think so. And the vendor's like, I've never heard of that. And they're like, well, maybe. Okay. Well, it kind of looks like it fits. As the court says, it's very hard to see why that mistake occurred, because the titles clearly say that the 3 titles of the farm were in the parish of Mangatawhiri, and the 4th title was in the parish, I think, of Pukekohe or something, a different area entirely. In fact, the title that was eventually included into the sale and purchase agreement was of a piece of land 12 kilometres away from the farm, and actually had the vendor's home on it. And so they put it into the document, And the purchaser says, oh, that's fantastic. I've got another title. I'm going to sell that as soon as I've got it, and I'm going to make lots of money on it, and ha, ha, ha. And the vendor says, oh, I would never have sold it for this price if I knew there was another title. I would have sold it for more. The reason for that is because it's very hard to get separate titles for rural property, at least at the time in the area. Such titles were valuable because you could sell them as separate parcels and people could use them for, there's a bigger market for people buying a smaller piece of property than a large piece. So you could subdivide it easily and sell it off. And the vendor says, oh, I didn't realise there was 4 titles. I would have asked for a bigger price, but if that makes up the farm, then well done, good luck for you. And the purchaser says, yeah, it is good luck for me. And then there's some evidence, and everyone laughed. And the judge says, oh, did everyone laugh? And the witness says, oh, well, it was actually mainly just the purchaser laughed. So everyone laughed at the vendor's expense, and the 4 titles were included in the final agreement. And then they signed, and then it came to the settlement. And that's when it was realised that the settlement included the sale of the vendor's home, not just his farm 12 kilometres away. Oh, sorry, it was 12 acres 10 kilometres away, beg your pardon. So the contract was signed, and then the vendor's solicitor discovered the mistake. And obviously the vendor's solicitor is exceptionally worried because there could be good grounds that they were either in breach of some duty of care to their client or just in breach of their contract that they had with their client to take due care and skill. Because it seems like a really bad mistake that the solicitor did. Anyway, so the one way around that would be to get the contract rectified. The vendor said, look, I'm not selling you my home. And the purchaser said, well, I'm not paying you any money unless you give me all 4 titles. That's what we agreed to. That's what's in the written document handed over. So the vendor went to court to say this contract with the 4 titles did not reflect our actual agreement. And therefore, Your Honour, it would be unconscionable for the purchaser to insist on this written agreement. Please rectify it, and then by taking out that 4th title and then enforcing that agreement as rectified. At trial, the judge held that the parties did have a common intention, which was to buy and sell that particular farm, and not to buy and sell that farm and another area of land 10 kilometres away. And that the intention was to buy and sell that farm irrespective of how many titles made it up. They never discussed the number of titles that made up this property prior to going to the solicitor's office. The only reason the titles were brought down was a means to an end. We want to buy and sell this farm. Okay, which titles make up this farm? The purchaser was not buying the titles, the purchaser was buying the farm. Those titles merely reflect what the farm actually was. The 4th title was added by mistake. It wasn't part of their bargain. And therefore the trial judge held that, ordered rectification, removing that 4th title and specific performance of the agreement of the 3 titles only, which was the sale and purchase of the farm. The purchaser appealed and said, no, the written document accurately reflects our agreement, which was to buy and sell 4 titles. We all had a laugh about it. Well, I laughed about it. And so the question was, what was the parties' actual common intention? What was their agreement? The Court of Appeal said, well, look, what was it that the purchaser thought he was buying? What did the advertisements say? Well, the advertisements were always come and see this wonderful dairy farm. The advertisements were all about this block of land that made up the farm. The purchasers, on the strength of those advertisements, went to look at that particular farm. The purchasers thought that the area was about 550 acres, but they didn't have any exact knowledge of that, nor did they know how many titles made it up. And they agreed to a price prior to knowing exactly the acreage or the number of titles of the farm, which is evidence that they were agreeing to buy the farm, not the legal titles that made up that farm. So the common intention was to buy and sell the farm as it was seen, and however many acres that was, and that the titles were only a means to an end. As I say, the whole mistake arose because there was some dispute as to the advertisement saying it was about 544 acres, and some said it was 550, and that was why they started looking for more titles. As I say, that's where the mistake comes from. The Court of Appeal, for our purposes, also said, and I'll just put it up here, that the law relating to rectification was not in dispute. And it comes from a Court of Appeal judgment, Jocelyn and Nissen, from the UK. The Court of Appeal in the UK said, in order that this court may exercise its jurisdiction to rectify a written instrument, it is not necessary to find a concluded and binding contract between the parties and to set before the agreement which is sought to rectify. What is necessary and is sufficient is to find a common continuing intention in regard to a particular provision or aspect of the agreement. So you don't need to show that everything was buttoned down and there was no negotiations at all prior to the signing of the agreement. You just need to show that the particular part of the agreement that you're trying to rectify was not subject to negotiations, that there was a common intention about that particular part of the agreement prior to the agreement being drawn up and signed. So if one finds that in regard to a particular point, so not the whole agreement, but just a particular point that you're arguing about for rectification, the parties were in agreement up to the moment when they executed their formal instrument, and the formal instrument does not conform with that common agreement, then this court has jurisdiction to rectify, although it may be there was, until the formal instrument was executed, no concluded and binding contract between the parties. So you don't need to show that there was a binding contract prior to the written agreement being signed up. So you don't need to show that the parties were in agreement about every single aspect of the agreement. They could have decided that the farm was the subject matter of this sale and purchase agreement and could still have been arguing about the price right up until the moment the written agreement was drawn up. That would not defeat a claim for rectification when the part that you're seeking to rectify is the subject matter, the farm. Obviously, if you were seeking to rectify the document in relation to the price, if the parties continued to negotiate about the price, you couldn't claim rectification. Okay, so you need to show there's a common intention about that particular part. Oh, sorry. So the question here was there a common intention to be bound right up to the time of agreement about that particular point? And the Court of Appeal agreed with the trial judge and said, yes, the common intention between the parties was to buy and sell a farm irrespective of the number of titles. That is, the subject matter of the... The subject matter of the title of the agreement didn't... to be bought and sold didn't change. It was always to buy and sell the farm. And the discovery of a fourth title... the mistaken inclusion of a fourth title didn't change that intention. They didn't suddenly intend to buy and sell 4 titles. That's why they were laughing about it because the price didn't reflect 4 titles. The price reflected the farm. And that's why they were saying, oh, it's a discovery of this 4th title. This obviously just goes into the contract if it's part of the farm. Why? Because we're buying and selling the farm. We're not buying and selling a number of titles. And this common intention, therefore, was not reflected in the contract as written up. It would be unconscionable for the purchaser to enforce this agreement when he knows he never bargained to buy the vendor's home. He only bargained to buy and sell the farm. Sorry, to buy the farm. It would be unconscionable for him to rely on the written agreement now. It would be a windfall to him thanks to a mistake in the drawing up of the written agreement. And therefore, that would be unconscionable. We're going to order rectification of this agreement, remove that 4th title, and hold the parties to the bargain that they actually reached, which was to buy and sell this farm for $223,000. And so the purchaser was successful. And the vendor was successful. And his solicitor would have sighed a big sigh of relief. Questions at all? Does that make sense? Yeah, in the middle.
Why does there need to be a continuing intention so long as it's being agreed at the time and if they just make a mistake in the contract?
Oh, so what they mean by continuing, why does there need to be a continuing common intention? What they mean is one of the parties didn't change their mind between reaching that agreement about that particular part and the time of executing the agreement. It has to continue in that the parties, one of them didn't change their mind, in which case there was no agreement. Yeah, that's just what it means. That you still aren't going backwards and forth about it. Yeah, no, good question. Cool, other questions at all? Does it make sense? Yes? Does the law about rectification make sense? Does the application of it in this case make sense? Yes? Oh, really interesting. So that's what, section 35, isn't it? Or whatever it is of the CCLA, yep. Okay, so tell me, how would that affect it? I haven't really thought about it. Let's think about it together. It would depend, obviously, on the wording of the entire agreement clause. Really, the entire agreement clause says this written document takes precedent over any previous negotiations. It would not, I would argue, preclude a finding of rectification, because the argument would be you agreed to that contract, including that entire agreement clause, mistakenly thinking that it reflected your actual agreement. And therefore, when you are mistaken in entering into that agreement, you can't then use part of that agreement to stop the courts going back and looking at that mistake.
So it's more focused on the intention of both parties.
The intention, yes. Yeah, and it's not just that one party so it's not that one party had an idea about it that was different to what was actually happening in reality. So entire agreement clauses often are trying to get around previous representations made by junior employees or something like that. It's not to prevent the courts rectifying an agreement so that it actually reflects what the parties agreed to. So, this agreement takes precedence over any other negotiations, where you're saying, well, the agreement, yes, that's right, but the agreement doesn't reflect those negotiations. There was a common intention, therefore rectification would be granted. So yeah, I think the answer is it wouldn't affect it. Great question.
How many cases does the from-branding solicitor's case given as well, mistake by the solicitor? Do you think it's because
How is this different from, so Bradley West Lister was a case of non est factum, or an argument of non est factum. To argue rectification in that case, they would have had to have said, we did not intend, neither party intended there to be a personal guarantee. And that's just clearly not the case. The bank 100%, or the lender, I can't remember if it was a bank or a building society, 100% intended that there was a personal guarantee in there. That was the entire point. If we're going to lend you more money, we're not going to do it on the security just of this company. We need extra security. And so rectification just couldn't be argued because there wasn't that continuing common intention. Good question, though. It's great questions. I love the way that you guys are thinking about drawing it back to other cases. Really good. That's what will get you good marks in exams. And most importantly, will make you a better lawyer, because it's not just about exams. Cool. Let's, I've only got a few more minutes left to go to A. Roberts. Although I said that it's about a common continuing intention, there are certain circumstances where the courts have been willing to grant rectification, where only one party was mistaken, and where the agreement clearly reflected one party's intention. But in circumstances where that party is prevented or is stopped by the courts from arguing their intention was in accordance with the agreement. So essentially, effectively what happened in this case is one party intended one completion date. The other party knew this. The other party drew up the contract, the tender of the first party, and changed one numeral in the entire contract and didn't draw their attention to it, and knew all the way through that they were intending an earlier a completion date, didn't say anything about it, and the court said, in essence, you were misleading that other party. And because you were misleading them, you cannot say that your intention was different that you didn't have a common intention, because you led the other party to believe you did have a common intention. Okay, generalities aren't very helpful. Let's go to specifics. Might be more helpful. So this is where a mistake is made only by one party, so there's no common intention, but the other party knew about it and effectively sought to hide the fact that the agreement didn't reflect that other party's mistaken intention or belief. So here was a contract for the building of a school for the council. And the council said, we want to build a school, please submit tenders. And they received one from the plaintiff company. And the company put in a tender. They were sold, oh look, you're one of the low ones, but you're not the lowest, why don't you have another go? So the company rewrote the tender with a lower price and a completion date of 18 months. That is a completion date in 1955. Yes, 30th of September 1955. During the internal discussions of the council decided, and this I'm not entirely sure the ins and outs of, but it relates to the price and I think the funding of the council. But the council didn't want an 18-month completion date. The council wanted a 30-month completion date. That is 12 months later. So they drew up the agreement on the basis of the builder's tender, except for one number, which they changed from 1955 to 1956. So you've got this whole contract based on the builder's tender, which is drawn up on the basis, the contract's drawn up on the basis of the tender with one little change. But we just won't tell you about that one little change, and we'll just give it to you. And then we'll have all these negotiations and discussions about the build in which you're talking about, oh yeah, it's going to be great to finish within 18 months. It's going to be great to finish in 1955. You know, we're working on a 1955 end date. We've got all the timelines based on 1955. And the council's like, oh yeah, it's quite good. It's good. Knowing full well that the contract that they'd drawn up said a 1956 end date. Now, the council probably should have read it more closely, but then again, they were being effectively misled by the council. So they didn't notice that the contract drawn up by the council on the strength of the company's tender had been changed in one respect only from 1955 to 1956. And they signed that contract. And only later did the company discover this changed and later completion date. And obviously they sought rectification. Your Honour, this 1956 completion date was not what we agreed to. We agreed to 1955. Please rectify this agreement to give effect to our common continuing intention. That's a problem. There was no common continuing intention. The council clearly never intended a 1955 completion date. They intended a 1956 completion date. So how can you say that rectification should lie? Before we get to that, though, this, you would argue, is an excellent grounds for rescission. That we made a mistake. We were mistaken as to what the contract said about the completion date. You knew we were mistaken because you made those circumstances under which we were mistaken occur. Therefore, it would be unconscionable for you to rely on this contract, and therefore we should get rescission. What's the problem with that? What's the outcome of rescission?
They want the contract to go ahead because they want the money for building it, so they don't want it rescinded.
Excellent. Rescission is void ab initio. There's no contract. That's a problem when you actually want to build the school. It's more of a problem when you're halfway through building the school. What do we do then? So that's why rectification is a far more attractive option for the builder. But it's also a reason why rectification is a far more attractive outcome for the court. And so the court says, yeah, there wasn't a continuing common intention as there was in Dundee Farms. Not that they mentioned Dundee Farms because this case is about 20 years earlier and in a different country. But Dundee Farm is an example of a common continuing intention. There wasn't a common continuing intention here. But they said rectification will be granted in circumstances like this, where one party was mistaken, the other party knew about that mistake, and they encouraged that mistaken belief. And they based it on this idea here, what appears, beg your pardon, to be a species of equitable estoppel. If one party to a transaction knows that the instrument contains a mistake in his favour, but does nothing to correct it, he and those claiming under him will be precluded from resisting rectification on the ground that the mistake is unilateral and not common. Effectively, you are not able to argue there was no common continuing intention, because the reason there wasn't was because you were acting, at the very least, in an underhanded manner. You had changed the document. You had led the other party to believe that the document had not been changed. You knew the other party thought the document had not been changed, and you said nothing. You were misleading them effectively, and therefore, because of your bad behaviour, you are prevented from arguing there was no common continuing intention. You are prevented from arguing that that agreement was never 1955. By your actions, you made the other party believe that the agreement was 1955. Therefore, you're stopped from arguing anything differently. Therefore, there was a common and continuing intention, and therefore we can rectify this agreement and enforce it as is. And so rectification was allowed. And the agreement was changed to the earlier completion date in line with the builder's intention and also in line with what the council led the builder to believe the council intended. Right result, slightly tricky reasoning, I think it can be justified. A wrinkle on the common continuing intention. One that we will wrap up, I think, on Monday, just to make sure we're all on the same page. Please reread A. Roberts. On Monday, we will also start the cases that have arisen from the New Zealand mistakes legislation. Read that mistakes legislation and start reading those cases with one of the best cases in contract law, Conlon and Oslin's, because it's such a bad decision. See you on Monday.